This meeting of the State Board of Cosmetology and Barber Examiners is now called to order. We'd like to take just a moment to recognize our visitors and guests as we're beginning to get started. I think we have some schools that are represented here. If you would, if you're an instructor or an owner of a school, would you please stand up and let us know who you are? What school do you represent? Share Perfection. Thank you for coming in. KI. Thank you for coming down. Coming in today. We have a high school group here that's an internal program they have in some of the high schools across the state. Every county doesn't have that. So, ladies, we welcome you and hope you enjoy your board meeting today. Thank you for coming. Okay. We need to begin by approving the minutes of the January 30, 2027 meeting.
We want to call roll.
I'm sorry, roll call.
We'll go ahead and, as you suggest, go ahead and call roll as Chairman Gillihan.
Present.
Vice Chair Kelly Barger.
Present.
Nina Coppinger.
Present.
Judy McAllister.
Present.
Patricia Richmond.
Present.
Mona Sappenfield.
Present.
Frank Gambuza.
Here.
Amy Tanksley.
Present.
Anita Charlton.
Present.
Yvette Granger.
Present.
Bobby Finger.
Present.
And Brenda Graham.
We're all here. Do we have a motion regarding the minutes?
Make a motion to approve.
Second.
We have a motion and a second to approve the January 30th, 2017 minutes. All in favor say aye.
Aye.
Motion carries. Before we get into the rest of the meeting, I would like to take just a moment and say welcome to our Assistant Director here, Mr. Glenn Kopchick. Thank you for filling in for Roxana. We all understand the circumstances of her accident, and our thoughts and prayers go out to her and our good wishes. Welcome, and we'll try to be gentle.
Thank you, Chairman.
Okay. The next item on my list is legislative updates.
Hi, everybody. Brian McCormack, Deputy Commissioner, Commerce Insurance, and I'm gonna sit in and listen to the legislative update. Just if you all have any questions, Cheryl's gonna do a great presentation, I think, for you. But I did just want to take a second. I know you were talking about Glenn here and the team. Obviously, we've been. I think we've discussed it, and I think you all are aware. We've been looking at streaming these meetings, and so we've been testing the streaming capability, and so. We're currently doing that today, and I contemplated sending Roxana the link, but then decided better of it. She probably couldn't just sit there and watch it. So, but I did want to say that their group here has done a really good job, and in her absence, I know she'd be really proud of the work, and so I appreciate your all's patience with them, and they really are working hard to make sure that you all don't notice, which it's hard to, as great of a job as Roxana does, but they've been doing a good job. So anyways, I just wanted to say that, and I'll turn it over.
Thank you. So first we're going to go over the legislation that is currently pending before the state legislature. If you look on your iPads, we're going to start with House Bill 0031, and that's also Senate Bill 33. I'll give you a second to review that.
That'll be number 3 on your iPad there on the beginning of that presentation.
So what this bill does under 62-3-109D of Tennessee Code Annotated, it adds to the individuals that can conduct in-home barbering services, those individuals with disabilities. So it expands the scope a little bit. Currently, this bill has passed on second consideration in the House, and it's been assigned to the Business and Utilities Subcommittee. And that assignment was made on January 31st. In the Senate, it has passed on second consideration as of February 1st, and it's been referred to the Senate Commerce and Labor Committee. Questions about that bill? Okay. Next, I would like to turn your attention to House Bill 0306, which is also Senate Bill 1194. And there was an amendment to that bill. The amendment is number 0006.
Zero zero 36.
I'm sorry, give me 1 second. This amendment makes the bill, and what this bill does, it expands the locations at which barbering services can be rendered and creates a residential barber certification that would allow one to render barbering services in the home of the individual to whom the services are being rendered. It does require one to hold a valid current certificate of registration as a barber in order to be eligible for the residential barber certificate. It adds a safety requirement that an individual pass an initial inspection of their equipment prior to being able to conduct residential barbering. And it ties the two licenses together. So if there's revocation or suspension of the residential barber certificate, it also requires such with the certificate of registration as a master barber and vice versa. Currently, the status of this, it has actually passed in the Senate as of February 13th, 2017. And it is on the calendar for the Business and Utilities Committee for March 8th, 2017. And it's placed on their calendar on March 1st.
You said that this bill also lets barbering be done in the home? And this what this is about?
Yes, it creates a residential barber certificate that allows a barber to perform services on the individual in their home.
Regardless of their health.
Yes.
And Section 3 says that the Board of Cosmetology and Barber Examiners is authorized to promulgate rules to effectuate.
Yes.
And then it's supposed to go in effect July 2017. That seems not plausible.
Right.
I thought there was an amendment that it postponed it to go in effect next January. Didn't I see that somewhere?
I believe there was such an amendment. I'm not sure why that's not on your presentation, but I believe I understood that an amendment was in place to delay that by another year, which would give us time to put rules in place.
I saw that somewhere, but
This one, I don't believe we need, whereas that we are creating an in-house barber, in-home barber. What is happening right now, I believe it will affect us economically. Also, why should our kids go to school, get grants, loans, this type of thing, just to go home and cut hair?
Well, the in-home, that's the home of the ill person, or you're just saying in a person's home, period?
this takes away their health issues. Regardless of their health, this is saying that a barber can go into a home and cut hair but he has to have an inspection of his equipment on the front end, and then he has to have this residential barber certificate. And we are supposed to make rules for this.
So not
we
a
regulate
barbering license.
Yeah, he has to have a barber's license.
But, you know,
And
you're
this-
regulating something you can't regulate.
One of the problems with this in terms of equipment, all he had to inspect is just a pair of clippers. That's it. This bill shouldn't go.
But
Members, let me just kind of put a pause here for just a minute. The information in front of us today is a bill that is already moved through the Senate committees and the House committees. These things have already been voted on. The board sent me down to the meeting after the last session, and they received our input. So they've already voted on these things. At this point, this is what it is.
This has already been done.
This has been done, and this is
house.
basically our notification that we will need to be thinking about how we're going to promulgate rules going forward and how we will address some of these issues. Whether or not you want to inspect something besides just clippers, and that very well may be. That's a process for our rules making meetings. But the information is before us as it stands today, with the exception of the additional time frame. Correct?
Chairman, I did verify they did add an amendment which would make the effective, in the Senate they did add an amendment which would put it January 1st effective date, and we raised that concern about timeliness and being able to promulgate rules as Mona mentioned. So
Ron, I wasn't there, but I heard from some representatives that Ron did a great job, and then I called a couple of my representatives and voiced my opinion negatively about this,
I did too.
and it didn't do any good.
It's going to pass. They already passed it.
Yeah, so they have their argument, and they moved it through quickly like they do everything else. And
Yeah, I was just going to say, this kind of reminds me of the apprenticeship situation, where we're finding out about it more after the fact than before. When I say after, even if it was not after the meeting was over, it was after the deal was done.
well, before it was done, though, Ron did go. And
No,
spoke
but
to
I'm
them.
saying it was done.
Yeah.
It just wasn't complete.
Yeah.
And really makes me sometimes sit here and wonder why I sit here.
Yeah.
I mean, because this stuff isn't even getting put in front of us or bounced off us with representing the industry and trying to make sure that we're looking out for the safety of the public. And what's going on here,
The house and
I mean, this is the beginning of the end of licensure, is what it is. And really where it's gonna start, you know, fortunately, I grew up in the inner city in New Jersey. People will go to your house and do your hair, whether they're licensed or not. So the brick and mortar barber that's doing it right down the street, who has a license and is adding to the community, is not going to have the customer. And people in houses without licenses, not paying taxes, is going to have the customer. And it's going to be the beginning of the end of licensure. This is very, very dangerous. And Ron, according to you, it's too late. But at the end of the day, it just keeps appearing to me that every time we get something, it's just day late and a dollar short.
Well, I was told that it's just a sign of the times, like for example, the Airbnbs, you know, and how can they make sure that they're paying taxes on that kind of business? And everything is sort of going that way. And I was advised that pretty much, yes, this is going to happen. And then, yes, it's going to happen to cosmetology as well.
Edix too, probably.
And that, so with the ball in our court, we need to be careful and think about the rules that we
Also, we
promulgate
need to
for
put in there.
these programs. That's where we come in, not necessarily on making decisions whether it is a deal or not.
Yeah, but as much as we put in all the rules we want, you
Send
show
it
me
to
what kind
them
of
and
task
they'll
force
send
we're
it
going to have
back.
to enforce those. It's going to be impossible.
Stretched as it is, you know.
We don't really have enough to do it now. So all of a sudden we're going to have people like chasing down like license plates to wonder where they're going to inspect it. It'll never happen. This is the beginning of a dangerous period for hairdressing and barbering. And your Airbnbs and Ubers and all, I get all that stuff, right?
Yeah, but that doesn't.
That's a different game.
It's a different-
People
yeah.
use these stories to try to compare them.
On people, you
It's a
know?
sign of times. Sign of times. We got to protect
The
people
safety
from
of
a
the
health
public,
issue,
yeah.
and this opens up a can of
And
worms.
two, if you're a barber
to-
and you walk in somewhere, you don't know if you're walking into somebody that's got a disease that you can catch. I mean,
This
so
board,
many
if
safety
this keeps
issues.
rolling the way it is and it goes into Cosmo, this board will be gone too. It'll be a sign of the times. The room
Hey,
will be
let's-
empty.
Let's go ahead and move forward. Frank, I know a lot of us
Yeah, I
share
understand.
those opinions, but
I understand.
let's move forward here and keeping a mind on how we might want to come up with the proper rules that would address some of these concerns and issues we have. That's our role at this time.
Okay, we have two more bills to look at today. Similar to the bill discussed before, we have a Senate Bill 0797, which is House Bill 710. And that particular bill opens up Title 62 relative to cosmetology, and it would eliminate the requirement that cosmetology licensees only practice in shops or schools, which would thereby allow cosmetology to be practiced anywhere without exception. This has passed on second consideration in the Senate on February 13th, 2017, and it's been placed on the Senate Commerce and Labor Committee calendar for March 7th, 2017. In the House, it has passed on second consideration as of February 13th, 2017, and it's been assigned to the Subcommittee for Business and Utilities. That's as of February 14th.
Senate Bill, which? I'm confused.
797.
797? Okay. I thought that had to do with the,
Page 9, Nana.
On the iPad.
Sleep in the,
I thought it had to do with the sleeping in a shop.
both.
Okay, and the final bill, that's Senate Bill.
I did just want to make a comment, as the legislation we were just talking about is cosmetology. I will say I think there's a lot of observations here about it. I did want to make sure that you all are aware where these they have not completed the legislative process. I did want to be clear on that. Neither bill has passed and signed by the governor, so I just want to make sure you're aware of that. So I didn't want it to, from our standpoint, and I think Sherelle has communicated where it's at in the process. You can make your own determinations about where you think that's going to be, but I did want to make sure you were aware that those bills have not completed the process.
Thank you. The final bill we're discussing today is Senate Bill 1303, and it's House Bill 1338. That bill adds a new requirement for anyone seeking a new certificate of registration or a license, as well as anyone seeking to renew or restore a certificate of registration or license, and that's both under the Cosmetology and the Barber legislation. It requires successful completion of a 1-hour course of domestic violence and sexual assault awareness, and failure to complete this education could result in one's certificate of registration or license becoming invalid and possibly subject one to fees. This bill does remove civil and criminal liability for those acting in good faith or who fail to act on information obtained during the course of employment related to domestic violence or sexual assault. And this bill in the Senate, it's passed on second consideration, and it's been referred to the Senate Commerce and Labor Committee as of February 13th. And in the House, it's passed on second consideration, and it has been placed on the calendar for the Business and Utility Subcommittee for March 7th, 2017. And that's the status as of March 1st. So that concludes what we have to present regarding legislative updates.
Sherelle, I do have a question about that first provision regarding the 1-hour domestic violence course. Is that something that is anticipated that the board is going to be expected to address with where we're going to obtain this course, going to develop the course? Is it something that's out there the legislature already has in mind?
That's something that's not clear, and that is a possible concern. If this does go into effect, we are going to need a way to enforce this law, and so there will have to be someone available who provides this course. This isn't something that the board itself could put on.
Web or something?
Particularly, those type items are not included in the curriculum in any school curriculum that's required right now. So that's something that might not be able to be addressed without a curriculum, as well as what's appropriate to be in such a course. So something to think about.
Yes, we will definitely, if this in fact becomes law, we would definitely have to make sure that we can enforce it and that we have a course that's a viable option for students and licensees. Any other questions or comments?
Sherelle, I received a message over the course of the last 6 weeks that other people have commented on in this message, but I haven't really been able to locate any bill associated with the chatter. But going along with that Supreme Court ruling and what was decided with North Carolina, the Tennessee legislatures are discussing the fact that putting together a bill that would actually make our boards illegal with licensees on them, and that the director would have the authority to veto anything that any board decision was made moving forward. Have you seen that put together anywhere?
Can I get back to you on that question?
We'll revisit that when Deputy Commissioner McCormick returns.
Thank you.
Anything else? Okay.
We are ready for the Ivy Institute School of Aesthetics, the new school.
Hey.
Good morning. Thank you for coming.
Morning. Hi. Start talking.
We have a new school application. We're going to take just a minute to review some of your paperwork here. If you have questions, feel free.
I was impressed with all the documents that we got on this. I mean, it looks like you've really done a good job.
Thank you very much. I've been working on this for about 12 years, and at first I wanted to put the school in Mississippi, but the laws have changed where we can open a freestanding school in the state of Tennessee. I pay taxes in Tennessee. My children attend school here in Tennessee, so I feel that my money needs to stay here in Tennessee. Thank you.
I did see that you have all of your costs and everything associated with your school spelled out. You have a refund policy. That's all good.
Yes, sir. I'm hoping once I get approval from the state, I set my format up to be in compliance with NACAS. I know I have to be open for 2 years, but I want to go ahead and set the precedent now so when that time comes, I won't have to worry about it. Just make the minor adjustments.
Natalia, at 5200 Park, is that those red brick buildings that's across from Woodland?
Yes, but they painted them. They're beige now.
Okay.
Everything looks good to me. Make a motion to accept her
A second.
plans.
We have a motion and a second to accept. I actually only had one question. It's
Yes,
in
sir.
your layout for your school.
Okay, let me pull that out. And let me put my glasses on. Thank God for the dollar store at 8 o'clock last night. Okay, I'm ready.
Square footage is fine, but I noticed that there's a section that's called out for adjacent tenant space, is that space that's occupied within your school?
Yes, sir. He's building a hallway behind my office in the reception area, so the students won't have to walk through the treatment rooms. Once some of the students are on the clinic floor after 200 hours, they can come through the hallway. So he's going to take from the behavioral center
Okay.
and take some of that to create a hallway to go back to the multipurpose / classroom, theory and practical room. And then I give them adjacent to go back to the break room as well.
You're going to be doing the apprentice program?
No, ma'am, not at this time. With my years of education in the industry, I feel that I can give a solid foundation, but I do hope to have some, if the board will allow, to have continuing education classes in the future, because there are a lot of extra disciplines and modalities that we're not teaching at the 750-hour program that I would like to add later on.
I would just remind you that any construction they're doing would need to be completed before the inspectors come.
Yes, sir. That's why I'm here today. As soon as I get back to Memphis, I'll be able to call the landlord and get everything moving.
Have any other questions? We have a motion and a second on the floor. All in favor, say aye.
Aye.
Opposed, say no. Motion carries. Good luck and congratulations.
Thank you very much.
The next item on our agenda is Sheer Perfection Academy, and that's a change of location. Is Sheer Perfection here? There you go.
This matter is a representation. The school was before the board last month, and there were some legal concerns involving the application. The applicant essentially wanted to close their White House campus and move their license to their Nashville campus, where they already hold a license. And there was a question as to whether what the legalities of doing that and keeping both licenses. There's no issue with consolidating a school, but being able to keep both licenses. Legal has reviewed this matter and determined that in order to have two full licensed cosmetology schools in one building, those schools have to meet the requirements of the law independently. So you literally need to be able to satisfy both requirements in full. And based upon our review of the floor plan, this would not be possible for these schools to be fully separated and meet the requirements of the law in this one building.
Members, you've heard the legal's opinion on this. Do you folks have the ability to have more space there at the new location so that you could actually have space for two separate schools?
Should we add more square footage to the building? Would that solve the problem if we added more square footage? Because we do have 4,500 of square feet right now.
If I'm understanding our interpretation correctly, you would need, yes, the separate square footage for both schools. You would need separate equipment, spacing, and staffing for both schools as well. For the new school, you would have to have all the same items, just completely separate from the original. That would work, I believe.
But because their goal is still to have the two different schools, different school numbers in the same space?
That's correct. If they merely wanted to close a branch and have more students under their Nashville branch with that license, there would be no problem. But here the goal is to have two licensed cosmetology schools in one building, and so it's problematic for the reasons stated.
They'd have to have like 4,800 square foot. That's what you'd have to have.
If you wanted to keep both school
Separate.
That's the debate.
That would be the question, yes.
Okay.
But we just need to vote whether, the question is, can they keep both licenses? No.
Not in the circumstance.
Right.
Okay.
Excuse me.
Mm-hmm.
I think there was a mistake because we received a phone call last week. It was from Caleb State Board of Cosmetology, that we were approved for this matter. So today we were coming here and under the impression that we were approved.
There was some confusion about whether or not they would make the agenda. So they were approved to make the agenda, but they were notified that they would have to stand for their application for a change of location. So that might have been the confusion as to whether or not they were going to make the agenda.
The office doesn't have the ability to just outright approve schools. That's why. Apologize for any misunderstanding.
No, it's okay. And then my second question is, because the two schools, even though they are both cosmetology schools, they do have two different license number, which, we all know that. But we do offer different programs under each license, so it's not like they are exactly the same programs under this, two licenses under the same roof. They are different programs that we offer. So
They would still need their own space and their own equipment and their own setups with instructors and so forth.
Just out of curiosity, what's the upside for you to typically merging two locations into one?
that's a very good question. Actually, the reason we're doing that is because the school we're transferring from White House is under accreditation. We are going through NACA's accreditation, and the school we have in Nashville, which is license number 156, we want to offer apprenticeship, which NACAS does not approve. So we do want to keep two schools under the same roof. And for cost reasons, it would have been great if the board approved that we have one location, two licenses under one location. But now it's, we have to go ahead and open a total new location now.
So this is, let me see if I understand. This is so that in the same building, one program could be apprenticeship and one program could be traditional.
Yes, ma'am, absolutely.
And the NACAS is preventing that.
Yeah, NACAS does not approve apprenticeship, and the state of Tennessee approved it. We do have a big community that needs that apprenticeship, so we want to continue offering that. But for commuting reasons and for so many financial reasons, we have to transfer from White House to Nashville. So we were under the impression that since we already have a location, maybe for cost savings, we can have both of them and still continue with our NACAS accreditation.
Thing is, it's kind of unintended consequences. The apprenticeship programs don't comply with most federal regulations, and because of time issues, the Department of Education only allows about 200 hours of training as an externship for any school. The NACAS group, which is just one accreditor, there's many accreditors out there, and they have similar restrictions on externships. It's what we call apprenticeships.
So you can't multi-use the same space. So
Right.
what we're saying is it could be the same building, provided it was two completely different build-outs. So you can't double dip. That's what it boils down to, yeah.
Okay, and without if they want to keep the apprentice programs within any of their schools, then that would effectively forfeit their accreditation and their access to federal funding for their students in the future. So,
That means if they were under the same license?
Yeah, NACAS would not approve them.
Right, okay.
It'd be one school by day and another school by night.
That's a mess.
okay, we've had a
Hold on,
recommendation
to
from.
have a school that's just apprenticeship, though, they don't have to have the whole setup, though, right?
They have to have the whole setup. They don't have
Has
to
to be a
have
full
the,
school.
they-
Have to have
they're
the
not
floor
accredited,
space, though, right?
Yeah,
If
they
you're
have to have
doing the
floor
apprentice
space.
program?
Yeah.
I thought you just had to have a classroom.
Clinical, yeah, because they don't have to have clinical space, is that right?
They're wanting to do more than just the apprentice work there.
They want to be a beauty school with an apprenticeship program.
No, I get it. I'm just asking if you open just an apprentice school.
Well, yeah, the school by itself is just the classroom, because they can't do any clients.
So then that makes sense that they could have like a suite A and a suite B, or floor 1, floor 2.
They wouldn't need what I'm saying is they wouldn't need a whole nother clinical floor to
Do an
move their
apprenticeship.
apprentice program to a different place. It would need its own address, its own building, correct? But it
Right.
would just need to be a classroom?
Classroom, yeah, because you can't do any, you were not allowed to do any clientele.
So on a
That'll be
positive note,
question
to
for
send
Cheryl.
her away with a progress, because I just,
This is a
I
mess.
think that when the apprentice programs, they were definitely fought against by the beauty schools because of NACAS. You know, they thought they were going to all lose their accreditation, but it became a choice. So now that it's all done, it still continued to be your choice. And I think that we just have to have a clear path for you so that, you know, you can offer these programs to students in Tennessee as a choice, not just beauty school choice, but it's about these students that can't do a full program or won't be doing a full program. So if we've already said all you needed was the classroom, what are we talking about here? I mean, I just don't.
Well, after they get their 750 hours, they can go and test. But now, up till then, they're doing nothing but book work and testing.
So would there
They're
be an
not seeing the
option
first client.
for her to apply
They're not
for a
shampooing, they're
new
not
school
doing nothing.
license?
So does that, well, she has 2 licenses. She's just trying
But
to
I
get
mean,
it.
if she just applied for a new school license with an apprenticeship only school.
I'm not sure she's wanting apprenticeship only. Are you wanting the apprenticeship school to be apprenticeship only, or a beauty school that offers apprenticeship?
I didn't know that I could have only apprenticeship
See,
program.
that's where the confusion
I mean,
is.
if that is that an option?
You
I
can
thought
have
we just
one.
get like a license
Yep.
for a cosmetology.
You can have just
Yep.
an apprenticeship
Can I-
student.
Only
Students would be
apprenticeship?
separate. You just want to have the apprenticeship program here
Uh-huh.
and the traditional program here. But you're talking about a school and a room, right?
But when you get students in there, if they're not separated from the others, they're going to be wanting to do the.
Is there a
shampooing
way
and
to
everything.
technically hybrid and meet qualifications?
That's my
Is-
question.
That's your question, right?
Legally, I don't think so.
Does legal have any comments on this situation?
The application before the board today is for a change of location of the current school, and as it currently is, that's what our recommendation is based on. If an application were submitted for something else, we could definitely review that at that time. And, you know, I think the board is doing a good job of presenting some ideas so that maybe the goals of sheer perfection can be accomplished. So I'm sure that they appreciate that.
Yeah, so she just needs to do some research on exactly what she needs to have for both of these. But today, I mean, there's got to be a motion to deny this, and I make
We're
that
going to
motion.
need a
Is
motion.
that your motion?
We have a motion to deny this application. Do we have a second?
Second.
A motion, a second to deny. Any other questions, comments? All in favor, say aye.
Aye.
Motion carries. We would encourage you to go back and rethink your plans just a bit. Contact the board's office and seek their guidance on the apprentice programs. There are some specific rules that apply to apprenticeships, and before you invest money or anything like that, I personally would recommend that you make sure you have a good understanding of where that will lead. Okay?
Just one question. If we have 2 separate suites under this, in the same building, so it is 2 separate addresses, would we be okay?
It will be 2 separate addresses, 2 completely separate set-up schools, 2 completely separate staffs.
Okay.
So you can't have an instructor probably teaching a clinic floor here and then running back and forth between. It would be something that's completely separated.
Okay, but it is okay if it's 2 different suite numbers right next to each other, because we're thinking about if that's.
I mean, I've been
That's
to your
illegal.
location. They have a beautiful school.
Yes.
I do have one comment. So I have been in schools where instructors actually have taught at 2 different schools.
They can do
So
that.
they can do that. Like your instructor from your traditional school could teach theory in your apprenticeship school.
Oh, okay.
Well, you just can't bring those 2 classes together. and
Right.
combine.
Right, yes, definitely, but we
Okay.
can have them separate, like separate schedules to teach in both schools.
I mean, the way that your school is set up in the mall,
Uh-huh.
I think this is easier than you think it will be.
Okay,
I'm very optimistic you can get what you want done. It just can't be under the same roof.
right, yeah, it can be 2 different suites,
Right.
but not the same, yeah.
Yeah.
2 different, no, I got it.
And I
Yeah.
don't think, and this is the question for the board, is that the second suite that would just offer the apprenticeship program has to have as much stuff as you have right now.
The point is, if we have to if we have to set up a whole new school, we might as well just offer, not just apprenticeship, because somebody may want to come in and be a self-pay and do apprenticeship or not do apprenticeship, so we,
You have lots of
I have
options.
that options, yeah.
And there's
Those would
extra
be
real
good
estate
choices.
there, right?
That's true.
There you
right?
have extra real estate. You're
Definitely,
good.
Yeah. There's a lot
Right.
of space in the mall.
So you're set up in a mall?
We're inside a mall.
Okay.
The Global Mall is more like the education now. It used to be the mall to go to, but now it's more schools and, Nashville State Community College is there. There's some karate schools, driving schools. Yeah, we would.
I
love
would
for the
really like to
opportunity.
see this get resolved with you, because you would really lead a path for a lot of people who are asking these questions, that do want to be able to have the opportunity of the choice of that location and for those students.
We would love to, set up,
Mm-hmm.
it's, there's so many different needs out there, and we're trying to meet everybody's. And NACA's accreditation is so important to us that we want to make sure that we're on the
Absolutely.
same path with them.
I'm that far with that because I wouldn't try anything to mess it up, you know?
No.
It's so hard.
Yes, it's already hard enough.
Yes.
Yes.
Thank you for coming.
Thank you
Good
so
luck.
much.
Good luck.
Thank you.
The next item on our agenda would be the K&I Academy, a change of location.
I'm sorry, Chairman, can we go back to the legislative updates?
Sure.
I have Anthony Glandorf here, he's chief counsel, and he was going to address the question earlier about the North Carolina law.
And I wasn't here for the question, so if the question could kind of be restated or what
Well, it was discussed, and the information was sent to me that our legislature is discussing, and I haven't been able to locate any kind of bill. And the decision would be made in the Tennessee legislature that would be aligned with what North Carolina did with the Supreme Court ruling, and that our board, because of licensees sitting on the board, would not really be legal unless the director of the Department of Commerce and Insurance oversaw it. And that director of the department would have veto power over the board, which would mean we would sit here for years and decide legislative matters, and then she would or he would have veto matter. So I'm just trying to align or figure out what they're going to, discuss and talk about.
Right. So the bill that you're talking about is it's House Bill number 326. It's Senate Bill 1217. There's been two amendments introduced on the bill. The second amendment is so the second amendment makes the bill, which means it essentially removes everything previous to. And I think some of the what I'll do is I'll go through just general terms as to what it does to help kind of explain a little bit of it. But yes, this bill makes an introduction, and it recognizes the previous Tennessee U.S. Supreme Court case, North Carolina State Board of Dental Examiners versus the Federal Trade Commission. And it basically reiterates what that board held about boards that could take some actions that would be considered in violation of federal antitrust laws. So what this bill does is it takes some of those factors that the United States Supreme Court said would help insulate board members on their actions. And so one of those was, one of the key points was that there'd be a supervising official, that there'd be a supervising official over a board that was made up of market participants who could oversee the board, and that there could be somebody who was separate from the board that could put the brakes, let's just say in general terms, put the brakes on an action that a board to make if that action that the board was making was an action that could be considered an unreasonable restraint on trade. That's what the opinion was concerned about. So what this bill does, and I'll speak in general terms, is it would affect this board, the Cosmetology board, and it basically would say that there's designated a supervising official, and the supervising official could be the commissioner of the department or a chief executive of the administration department, or the commissioner's or officer's designee. So there would be someone in the administration would be designated, either the commissioner would designate that person. And so what that person's responsibility would be under this amendment was to ensure that the actions of the board that displace competition, so only the actions of the board that displace competition, are consistent with clearly articulated state policy. And that's what the Supreme Court case was looking at, was trying to determine whether or not if there's going to be an action that restrains board, if there was going to have, if the restraint that the board was making had a clearly articulated state policy. And so what it says is it says that any action that the board takes other than rulemaking, it starts out by saying other than rulemaking, the supervising official can, first off, they evaluate whether or not that action is a potentially unreasonable restraint on trade. Because that's all they're looking for. Not all the actions of the board, but just those actions that could be considered an unreasonable restraint on trade. And so they can say if there's an action by the board and it's determined that it takes further review, what they would do is they would provide the board notice within 10 days of that action saying, I'm going to take this under review at my level. And so basically there would be a pause of that action. And what they would do is review the evidentiary record, the minutes of the meeting, what everybody said and whatnot. And then they would basically go back and they would say, they would put in writing, they would either approve that action and it would go forward. They would in writing. If they gave notice, hey, I'm going to review this, then they have to either in writing approve that action and say, hey, I've looked at this is fine. Or they could remand it back to the board, which is bring it back to the board, and that action wouldn't go further, and they would have some instructions on some proceedings, potentially a modification or whatnot, but they would be providing this back to the board. Or the third thing they could do is they could veto that action and say, no, we're not going to do this. As the supervising official, they would basically be saying this is unreasonable restraint on trade. It's not basically part of a clearly articulated state policy for a restriction on trade, and then they would do that. It has restrictions on the on the supervising official. That person could not be licensed by the board, within the industry. They couldn't have any financial interest within the occupation or whatnot, and they can't be a voting member of the board. And so And then if they were going to take any action or they had any kind of a review action, they would have to report that back. That supervising official would have to report that back to the Joint Government Operations Committee, and it's just a report back to them. So that's actions that the board would take. So far as rulemaking, there's a separate section regarding rulemaking, and this had been amended from previous versions, and it basically says that what they can do is they can remand a rule that may constitute a potentially unreasonable restraint of trade to the board for additional information. So that's essentially what they do for rulemaking. So the way that basically to look at it is that this supervising official it's basically modeling what the Supreme Court case said, is that it's creating the supervising official, number one, because the state of Tennessee previously didn't have it. And then it says any actions that the board's going to take that has potentially an unreasonable restraint of trade, then they would review actions like a cease and desist order or something like that. That was the example in the North Carolina dental examiners, and they could review that to see if it's an unreasonable restraint on trade. And then for rulemaking, they could basically look at the rules and say, is this an unreasonable restraint on trade? If it's a restraint on trade, would it be part of a clearly articulated state policy? Which gets back to the decision which said states are allowed to restrict trade if they want. But if boards are going to do it, it has to be part of the state's policy to do it, because you're market participants.
I'm sorry. Go ahead.
No, so that's what they would. So that's essentially what they would do.
The executive director automatically the supervising? No.
No, it's not the executive director. So Roxana Gamusio is your executive director. That's not. It's not. No. It would be what it starts out as. It says that the commissioner. And maybe there's some confusion, but it's the commissioner or the chief executive officer of the administrative department. That's generally the deputy commissioner or the assistant commissioner level, or that person's designee. So it would be, so they could designate any person to do that.
It's just for regulatory boards?
So this one right here, let me see.
It's for any board that has a licensee on it that actually votes on our business.
So it's any state board, commissioner, council, or committee, that issues any license, certificate, registration, certification, permit, or other similar documents. So it's not within this department. It would affect other departments that have similar makeups, boards, commissions, councils that issue licenses.
Like a school board. I mean, I'm just saying, is that also included? Like if you have a teacher's license?
I'm not sure. I haven't looked at it in the
Is this going?
in realms
Is this
of
going pretty
schools,
strong? Is this sailing through?
This?
Yeah, this bill.
So this bill is
Who introduced it?
This bill is sponsored by Representative Hawk in the House, and I believe it's Norris in the Senate. But I'd have.
What?
So it So I think other ones you could look at: Department of Health, doctors, boards, commissions, things like that. But I don't know about honestly about teachers boards. I'm not really sure how the teachers boards make up. I'm not really familiar with those.
There's licensees on there.
If they give licenses out and their boards or commissions.
Well, I just.
That definitely affects like the Board of Medical Examiners, our board.
Yeah.
In this department, it would be the auctioneers.
Well, it'll be all the boards under the regulatory board. Under our division, it'll be all of our boards that issue out licenses, permits. Essentially, it's all of them that are boards, yes, and commissions. It'll be all of ours. I mean, it's a holistic view for all. The idea is that it protects all. It's supposed to give protection to all of the board members, commission members, council members that are appointed in the state of Tennessee, so that Tennessee has those safeguards, so that the Federal Trade Commission doesn't come back. That's what happened in that case, and it came back and said, "Oh, you board members are doing what we would consider to be an unreasonable restraint on trade. You all are market participants." And there's no mechanism within the state that could safeguard that type of action. So what they said in that opinion is that the individuals could be held personally liable or responsible. So that's what...
It may not apply to that because they're elected. The school board I'm talking about, they're elected, so not appointed. So that might make the difference. You said appointed.
Well, you're talking about school boards.
I'm just thinking
sure.
that might exclude them. I was trying to think of who it affects, but it affects us.
It affects this board.
Contractors, everybody.
Mm-hmm.
I don't know that they would affect trade, Nana. You know what I'm saying? Like,
you're welcome. And this, like I said, this is the second amendment that's on this bill, and that amendment makes the bill. But it's SB 1217.
Thank you very much, Tony. I think we're ready to move back to the KI Academy, change of location.
good morning.
Thank you for being here this morning. Where is your school located now?
My school is located in Henderson, Tennessee.
Okay.
And over the Christmas holidays when we were closed, our back wall, water had came down. We had like A-line winds, and it took off the front awning. And luckily nobody was in there. We had like 6 inches of water. So a lot of stuff got really, really wet. The move is only 8 miles. However, it is across the county line. We've been able to keep everything else the same.
When I look at your location, you're going to 3,710 square feet. The location seems to have plenty of square footage. I didn't see any really outline here other than some notations for the clinic and the classroom floor. You didn't have any equipment layouts or anything like that.
Yes, sir. Like shampoo bowls, we had those going down a wall adjacent to the bathrooms on that wall. We basically have moved from a 4,000 square foot to a 3,700 square foot. It'll be the same equipment and everything.
Same equipment. Okay.
Same teacher, same.
Okay. Have you been closed all this time?
Yes, sir.
What have you done with your students?
We don't have NACAS. I went out to Salt Lake City and did all the classes and stuff and studied the book and then decided not to. So I thought that might help a little bit with what the other lady was discussing. Mm-hmm. But we haven't done apprenticeship yet or anything. But
since you're only going about 8 miles, I assume there's not going to be a terrible hardship on your students to make an extra drive.
No, sir. I told them no spring break, probably nothing in the summer. We've only missed, I think, about 6 to 8 weeks.
Can't help Mother Nature, so.
It was shocking. At the very worst, under 3 layers of roof had come down, and there was even 2x4s laying in the floor that were like A-framed, and I knew we had problems. And when I went over to it, you could see daylight. And so we had to shut off the electric. We went to the electric box, and water was gushing down that wall. It was just very unsafe, but nobody was in there but myself, and we shut everything off and moved. And I thought it would be easier than to move back, so we're going to stay.
I make a motion to approve.
Second.
We have a motion and a second to approve the change of location. Any other questions?
I'll just comment. One issue that came up was when this would be ready for inspection, and if you see on the application, it has question marks in April. It has the date April 6, 2017, and we just want to make sure that it's understood that this would be contingent upon passing the final inspection, and that this wouldn't be able to open and operate until that actual inspection occurs. So, but that's all I had.
Where is Henderson? It's closer towards Memphis. I left at 4:30 this morning.
We have a motion and a second on the floor. All in favor to approve, say aye.
Aye.
Motion carries. Thank you for coming and good luck. We are down to the administrative report.
All right, we have our applications for examination, and if you turn on your iPad, the first page after you see applications for examination is actually hours, and those hours are shown for a number of students, but the one we're concerned about today is Miss Christine Smith. She has submitted a request to the board that she be allowed to test for her instructor's license. She attended Pyramid back in 2014 and alleges that she completed instructor coursework, the instructor program there, and would now like to test. The reason you have the hours before you is that there are some discrepancies with the hours. The hourly report for April, she's on the report, but it shows 0 hours completed. The hourly report for May, she's on it. It shows 28.5 hours completed, but a total of 28.5 as well. For June 2014, the hourly report shows 0 hours completed, but somehow her total increases to 101 hours from 28.5 the month before. The report for July 2014 shows 71.72 hours completed, and somehow a total of 306.72 hours, where it was only 101 hours the month before that. And then finally, the hourly report for 2014 shows 0 hours, and she's still at 306.72 hours. And then in the month of September 2014, she completely drops off of the report. She says that she completed her training, but she was never put in the test by the school because they closed before the hours were submitted to PSI. If you all remember a little bit of the history on Pyramid Beauty School, they'd had some issues with their hours, with properly reporting their hours, etc. I have a consent order from back in 2015, and it references a complaint about the school's failure to accurately and ethically maintain, report, and credit hours to students. And back then, the board suspended the school's license for a month and reinstated it with the stipulation that all monthly hour reports would need to be accurate moving forward. And then when the last major action was brought against Pyramid to revoke their license, there was a United States military veteran who also complained about the way hours and attendance were being kept. And he actually stated, Mr. St. Clair, that the school, the respondent at the school said they would not report hours attended by students if students disagreed with respondent regarding classes, duties, and payment of tuition. So we have an interesting situation here. I think you all have, I think over the past 3 years or so, you all have reviewed a few of these applications, and Pyramid students have been allowed to appear and kind of state their case. It's my understanding that Ms. Smith was informed that she would be on the agenda, but I don't think she's here today. You all have a challenging call to make. On one hand, we have records with huge discrepancies that don't support that the education was completed, and then on the other hand, we have a school with a history of not properly reporting hours. And so we thought that this issue would come before you, and you all would ultimately have to make the decision as to whether or not you want to let this person test.
Members, if you remember, we had several of those cases, and I think what we did at the time was if they could produce some credible evidence, verifying hours, any kind of evidence that look at and make some kind of determination for them, that we had tried to offer some kind of consideration for those students. I don't see a lot of that here myself. I see that particularly where those hours jump, if we have someone who's not on there, we don't have any enrollment documentations here. We don't have anything that says this student actually even signed in other than they're showing up on a report, which was consistent with Pyramid at the time. When you go from 100 hours to, was it 300 hours over 1 month, that wouldn't be legal anyway, because there is a limitation, 48 hours, 40 hours per week, and so many hours per day maximum. So the math just wouldn't even work out. Even if the student was attending regularly, the math still wouldn't be correct. For me, unless I saw some more evidence, some more foundation groundwork showing that they had actually attended these hours, I would personally not be in favor of.
Well, you know, we've, even with our foreign applicants, depended on our testing to see if that was accurate, and we've always kind of assumed that if they have the hours and the paperwork is honest, that, you know, the test will prove differently if they don't have the hours. And I've worked on that instructor's exam. I think it's a pretty stringent test, and I think she'd have to have some instruction to be able to pass that test. I would like to maybe consider it and stand on the merit of our testing to get her approved.
I'd like to hear what she has to say. I know she's not here, but that would be helpful.
Is there any, like, qualified reason why she's not here? Was it an excusable absence, or just chose not to attend?
No, she was notified. One of our license tech kept in touch with her, but in this regard as well, really, we checked and she didn't even have an application, so it would really just be deciding on her hours whether or not we would approve the hours.
I'm not comfortable with that yet, Mom. You know, I agree with you thinking, but I think there's got to be a little bit more kind of willing. Yeah, what if she passed the test and then she didn't, you know, say she skins by it and everybody else had to do what they had to do? Okay. Again, I'd like to hear from her. I'd certainly have a few questions, because I hate to have that 1% chance that, you know, you're denying somebody who, but there's too many dynamics here that just point in the wrong direction for me to feel comfortable with going that way.
I guess, too, with the time delay, I mean, if she's last attended school there a couple years ago and we haven't heard from her since, why now? Because the last hours were, what, 2014?
I believe that we reached out to as many of those students at the time that we could contact based on the information we had. So,
Mr. Chairman, if you like it, we could, if you so chose, do a motion to submit an application and appear.
This is not a formal application before the board, so,
We definitely can't approve these hours.
right, we
just
can't
so-
approve just the.
If
just
that's
hours.
the
We don't have an
request.
We
application
could
in.
ask her to appear.
Would we have a motion to have her submit an application and appear?
Yes, definitely.
Motion, do we have a second?
Second.
We have a motion and a second to submit application and have her appear. All in favor, say aye.
Aye.
Motion carries.
okay. Next on the agenda, we have our felony applicants. We have Miss Chelsea Ladd, and you all can review her documentation for a minute.
Make a motion to approve.
Second that.
We have a motion and a second to approve. All in favor, say aye.
Aye.
Motion carries.
Next, we have Mr. Evan Thomas, and his documentations are on your iPads as well.
Attended a TCAT school, I believe.
Make a motion to approve with a signed agreed order.
Second.
Second. We have a motion and a second to approve with the signed agreed order. All in favor, say aye.
Aye.
Motion carries. A bit of housekeeping, because I believe you left the consent order off of the first one. Would you like to make a motion to add a consent order to that?
Yes, I would. Add the consent order to the prior.
Add, and we have a second by Mr. Finger. All in favor, say aye.
Aye.
Motion carries. Sorry about that.
Okay, next on our agenda, we have our international applicants. The first one is Shaylin Hassan.
This one had 100.
And it says 800 hours.
It appears those hours are in hairdressing. I know he's applying to be a master barber, so that's something that the board will want to consider.
It says that he attended Genesis Career College. Do we have any of those records in this?
We do not. And we're not sure if he completed
Right.
there or why he didn't submit any of that documentation. We only have what we received from his education abroad.
This would probably be another one I'd like to, more documentation and ask them to appear. Just provide the, how many hours he did at Genesis and see where he's at then.
Well, if he attended there and they've not released his hours, he wouldn't have anything to.
copy of completion, but not maybe paid off or something.
Typically for international students, if he is applying just through his international status, we have allowed these generally with both tests to be taken.
Chairman, I move that we allow both tests to be taken.
We have a motion and a second to have this gentleman take both tests. All in favor say aye.
Aye.
Opposed say no. Motion carries.
All right, the next applicant on the agenda is Jacqueline Santiago. Manicuring license application.
Rated 600 hours.
That's what her documentation reflects at Serbia's Technical College Incorporated. Looks like it's in Puerto Rico.
Make a motion for her to test on both parts.
Second.
We have a motion and a second to require both tests. Any other discussion? All in favor say aye.
Aye.
Motion carries.
Right, the next item on our agenda, we have a miscellaneous request. Business owner who wrote the board, and it wasn't exactly a question, but the individual had some concerns, so we agreed to present that information to the board, and you'll find that email exchange on your iPad. And the board doesn't need to take any action. This is just something that is before the
It's the website where you can schedule an appointment, is it?
App.
Pick your...
It's an app.
To schedule an appointment and choose your person? Okay.
Perhaps this person just needs a copy of the legislation that's coming through.
Decipher.
I didn't understand the photo shoot loophole. Can you explain that, what they're referring to?
Well, basically, under the law, if it's a photo shoot, it can, those services, cosmetology services, can be rendered outside of the shop setting. And so,
Oh, yeah, okay. I know
what they're saying is that these aren't truly photo shoots in the traditional sense, but they are taking pictures and using the photo shoot exception.
Okay.
And for a rude awakening when this other bill passes.
Yeah.
Alrighty, we'll move right on to the reciprocity applications. We want to get a committee update, Ms. Nida.
Oh, okay.
All right, Nana, all
It
right.
was short and sweet. We had 4 cases of reciprocity. 2 of them we voted to grant reciprocity. 1 that we required them to take both exams, and then 1 we asked for more information. So we just need a motion to accept the reciprocity report.
I'll make a motion to accept your report.
I second.
We have a motion and a second to accept the report. All in favor say aye.
Aye.
Motion carries. We have the director's report, financial update. Good stuff.
All right. Well, it looks like we'll have some good things to report. We're in the black, so that's always good. We always look forward to that. Just quickly, it looks like in January we netted, or excuse me, we grossed in the black at 194,994, and it looks as well. That was the gross, and then of course with the cost, that was 182,778, with a I guess a gross balance of 42,216, and then for the year we have a balance of 122,329. Is there any questions on that report?
Make a motion to accept the report.
Second.
We have a motion and a second to accept the report. All in favor say aye.
Aye.
Motion carries. It's always good to be in the black.
All right, the next item on the agenda, we have our staff attorney report, and we're going to start with our legal report.
Good morning, everyone.
Hello.
As you're reviewing the legal report this morning, all of our recommendations were approved by the committee this morning. I have numbers 1 through 10, if anyone has any questions, and then Allison has the remaining complaints.
I think I know the answer to this question, but there was a case where it's basically a third strike on someone operating without licenses. How did you guys come out on that one?
That's Allison's case, so I'll defer to her.
On 16, our recommendation was accepted to pursue voluntary shop license revocation. It's voluntary because we're trying to settle, whereas it would be involuntary if we bypassed that step and moved for formal charges to revoke without them, without their will, I guess.
Blast first and then see where we go.
Ask nicely.
Yes, I mean, essentially this follows the same sort of 3 strikes for unlicensed activity and you're out, regardless of whether you've paid the fines.
And I think that decision was reached because if we were to just wipe out the fines, then that would negate other licensees' incentives to pay their fines, even if their license status is at issue for other reasons. So those cases are currently in a litigation pending status where I haven't filed the formal charges yet, but will add formal charges for the license revocation in addition to pursuing those civil penalties for those 3 instances of unlicensed activities. Don't go away if you just ignore the penalties.
Do we have any other questions? Okay. We need a motion.
I'll make a motion to accept.
Second.
We have a motion and a second to accept the legal report. All in favor say aye.
Aye.
Opposed say no. Motion carries.
Thank you.
All right, next on the agenda is a report regarding our agreed citations. On your iPad, you can see Since our last meeting, we've collected $7,100 in agreed citations. And moving to the consent report, we've collected $10,250.
We would need a motion.
Make a motion to accept.
Second.
We have a motion and a second to accept the consent orders. All in favor say aye.
Aye.
Motion carries.
That also includes the agreed citations, correct?
Yes.
Okay. Moving on to new business. At our last meeting, we had planned to have a rulemaking hearing for mobile salons, and those are not actually ready to be presented to the board at this time. They're being reviewed by the Attorney General's office, and they require a longer notice than previously realized, 54 days, I believe. So we want to have the board today approve a new date, and we're looking at the date of May 8th at our meeting that month for that hearing. So we're asking the board to authorize us to conduct a rulemaking hearing at its May 8th, 2017 meeting.
Motion to put the rulemaking on the agenda for the May 8th meeting.
Second.
We have a motion and a second to place the rulemaking hearing on the agenda for May 8th.
I'm not sure if that requires a roll call, but just out of an abundance of caution, I would like to go ahead and do one.
We will do a roll call vote.
Yeah.
On that motion, Chairman Ron Gillihan, sorry.
Yes.
Vice Chair Kelly Barger,
Yes.
Nina Coppinger,
Yes.
Judy McAllister,
Yes.
Patricia Richmond,
Yes.
Mona Sappenfield,
Yes.
Frank Gambuza,
Yes.
Amy Tanksley,
Yes.
Anita Charlton,
Yes.
Yvette Granger,
Yes.
Bobby Finger, and Brenda Graham.
Yes.
Thank you. Next on the agenda for new business, a case status update regarding our Noel Pritchard lawsuit. We recently had a motion to hold this case in abeyance court until the conclusion of the legislative session, and the chancellor did order that. So that case is stayed until the legislative session is over, and depending upon what happens or doesn't happen will determine the next course of action. So I wanted to provide you all with that brief status update.
Does that change next week's meetings?
Yes. Everything is basically paused for the next couple of weeks until the legislature concludes its session. The final item under new business today involves a summary suspension. I'll give you all a second to review those news articles, and we'll talk about that. And that involves Mr. Dan Van Tran, South Knoxville nail salon owner.
Been convicted of this yet?
No, he's only been
So he's
arrested.
just been
He's
arrested.
not been convicted of this.
The request is for a summary suspension, not a revocation. Right?
That's correct. And under the law, TCA 4-5-320C, says if the agency finds that public health, safety, or welfare imperatively requires emergency action and incorporates a finding to that effect in its order, summary suspension of a license may be ordered pending proceedings for revocation or other action. So today, you all need to review the facts of this and determine whether this imperatively requires your emergency action to protect the public health, safety, or welfare of the public. And if so, you all have the right under the statute to vote to go ahead and summarily suspend this license. But in doing so, we would have to have a hearing within 7 business days and give him, the licensee, the opportunity for an informal hearing that could be conducted over the phone, so you all would not be expected to appear in person, but we would need to have a hearing informally and give him the opportunity to present his side, even though you all could and have the statutory authority to go ahead and summarily suspend his license today if you conduct within the parameters of the statute.
Has everyone had an opportunity to read this?
What's legal think?
This is certainly you all's call. The statute says if you all find that the public health, safety, or welfare imperatively requires emergency action. That's what you're trying to determine. And here we have somebody who's been arrested. We're not sure if he's been charged. He certainly has not been convicted of these acts, but you also have kind of information about what those acts are in front of you. So that would ultimately be a determination whether you all think it meets that threshold. And, you know, if you do, you have the authority to take this action, and this is something, you know, we deemed appropriate to bring before you, as we would with these kinds of things that happen with our licensees involving crimes and such.
We could vote to suspend his license? Is that what we would do?
Yes.
Yes, you all could vote today to do a summary suspension, and what we would do, we would have a hearing. I'm assuming most of you all would appear by phone for that within the next 7 business days. He would have the opportunity to appear. It would be an informal hearing, and then at that hearing, we would conduct that hearing, and ultimately a final order would result from that. And this isn't a revocation, but it's saying that he can't do business for the time being. And that would be certainly you all's call to make, but we would need to set a date and a time today for that hearing if you all voted to summarily suspend his license.
If we voted to suspend his license and then when he's formally charged or not charged, if this proves not to be true, the women made it up or whatever, what does that do to us?
I think as far as your liability, as long as you all have made that determination that I've discussed, and you've analyzed this conduct and determined that you're not making a finding that he done these things. You're finding that based on what's being alleged, it requires emergency action. Imperatively requires emergency action. So you're not making a finding today as to whether or not he actually did these things, but you all would be acting within your statutory rights to do this if you chose to, or if you chose not to do so and to let it play out in the justice system. That would be your option as well.
But if we don't do this, he would continue working, correct?
Well, assuming that he could, if he was released on bond, and he may already be, we haven't contacted Knoxville Police for an update on this, but yes, he could go back to work, assuming he was out and free to do so.
I feel like we're asked to be a jury of some
and
sort.
we don't have no case in front of us.
And then he's just going to practice unlicensed because he probably needs, I don't know. I mean, it's so he said, she said right now to us.
I will say that there has been comments on both sides. I can't believe that happened. He's done my nails for years. I agree. That's like his demeanor, But so, I mean, there's no way to know, really.
I don't feel comfortable myself voting one way or the other on that because hasn't been. I mean, you're innocent until proven guilty.
I'd like to know more about it myself.
Yeah.
I can't do that.
We don't have a motion on the floor yet, so
It's two different women that are making the same allegations, right?
Yes, that's correct. These stories show that there are two different victims making similar
Very similar accusation.
Is his shop still open?
Like maybe two good friends?
I don't know. I don't know, but they said the same story.
Because the neighborhood itself would pull, I would think the women would pull back if they believe that to be.
I know there are other people that work in that salon, not just him.
We haven't checked to see if it's remained open since he was arrested. I mean, he certainly has the right to be open, but as far as whether he's actually operating since all of this happened, we're just not sure today.
How did this come to the board's attention? Just through the news and media, or was there a complaint lodged with the board?
There was an inspector, I think, that worked that area that was aware of it, you know, just from other contacts, and then brought it to our attention.
Make a motion not to do anything until we have a conviction or something.
Second.
We have a motion and a second to not summarily suspend this license at this time until we have further information. Any other questions or discussion? All those in favor say aye.
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 Opposed say no. I'm going to abstain on this vote. The motion carries.
Thank you. At this time, we've concluded all of the new business. If there is nothing else, we are prepared to adjourn.
Early.
What?
Can't we stretch this out 2 more hours?
We can go to lunch. We never get to do that.
Before we have a motion and a second to adjourn, before we vote on it, I would like to say again, thank you to our staff in our office. Glenn, thank you for stepping up, and as we speak with Roxana, please give her our best, and if you need anything, give us a call. For our students in the back, I hope you enjoyed your day. Hope you learned something, and hope you'll go out and be wonderful practitioners and make lots of money. Okay? Do we get some ayes here? All in favor, say aye.
Aye.
Motion carries.
Thank you all.
Thanks,
We're
Ron.
adjourned. I have collected